I think we should, oh, there's 12 o'clock. So good afternoon, I can say to everyone. And thank you so much for joining our webinar, What New Privacy Legislation Could Mean for Ontario Nonprofits. This webinar is brought to you by the Ontario Nonprofit Network. My name is Liz Sutherland, and I'm the Director of Public Policy here at ONN. If you're new to ONN, welcome. We are the provincial network for Ontario's 58,000 nonprofits and charities, focused on policy, advocacy, and services to strengthen Ontario's nonprofit sector as a key pillar of our society and economy. If you're already a member of ONN, welcome back and thanks for your support. Our work would not be possible without you. Just while we get warmed up, please do fill out our second poll on what you are looking forward to learning about during this webinar. If you're okay to post the second poll, Melanie, that would be great. So are you interested in learning what the Ontario government is planning in the way of new privacy legislation affecting nonprofits and how this affects you? Are you interested in learning about opportunities for nonprofits to play a role in ensuring data justice and equity, protection of privacy, and the principled use of data for public interest purposes? Or learning how you can engage and influence the government on forthcoming legislation, or sharing your questions in a live Q&A with nonprofit representatives who are engaged in this privacy legislation development. So just take a minute to fill that out and we'll move on. A couple of housekeeping notes while you do that. If you are experiencing any technical difficulties during the webinar, like a visual lag, try closing your browser window and reopening it. If you still have trouble, then you can type the issue into the chat box. If you have any questions for the webinar presenters, please type them into the question box and we'll get to as many of those as possible during our Q&A in the last 15 minutes. And to answer your most common question, you will receive an email in about a week with the recording and the slides. We did put this webinar together on very short notice when the privacy legislation consultation was extended by a couple of weeks. So I told our presenters not to worry about slides, but there are a few, so we'll send those as well. So let's close the poll and have a quick look. How are we doing? All right, of course. So the greatest interest is in how the proposed legislation on privacy, what it's going to look like and how it can affect your organization. And we've got a significant number interested in data justice and how we protect privacy as well. So that's great. Thank you very much. So before we get into the conversation, I wanted to acknowledge that ONN is working on the traditional lands of the Huron-Wendat, the Haudenosaunee, and the Mississaugas of the Credit. This territory is part of the Dish with One Spoon Wampum Belt and the Upper Canada Treaties. I'm joining you from Perth, Ontario, which is on unceded Algonquin Anishinaabeg territory and part of a large-scale land claim presently being negotiated between the Algonquin Nation and the Crown. At ONN, we believe that as nonprofits, we have to take seriously our role in responding to the Truth and Reconciliation Commission's calls to action. And as settlers, we're very grateful for the opportunity to live and work on this territory. So let's talk data privacy. Speaking personally, and I'm the chair of the Data Policy Coalition's steering committee that we co-convene with Powered by Data, I work very closely with nonprofits and governments on issues around personal data. So I know it's a very important moment to be talking about personal data, what we have and what we share, who owns it, who can access it, and how it can be used for good or abused in ways that violate privacy or the public interest. So whether you're focused on data privacy and data justice for equity-seeking groups, or just trying to make sure that your nonprofit follows the rules on safeguarding privacy, the legal and ethical frameworks governing data systems matter now more than ever. So today's webinar speakers include, and we've got three people who are going to present, and someone I'll introduce in a sec, who's here to say a few words and then mostly listen. But our presenters are Teresa Scaza, first of all, who's the Canada Research Chair in Information Law and Policy and a full professor at the Faculty of Law at the University of Ottawa. And Teresa will give us an overview of the state of privacy legislation in Canada and what we can expect in Ontario based on the experience in other jurisdictions. Second, we have Brenda Mcphail, who's the Director of Privacy Technology and the Surveillance Project at the Canadian Civil Liberties Association. And Brenda will raise important questions about data privacy from a civil liberties perspective, including what nonprofits should already be thinking about. Third, we'll have Rodney Burns, who is Chief Information Officer at the Alliance for Healthier Communities. Many of you probably know that the Alliance has led groundbreaking work on race disaggregated data in the context of promoting health equity. And so Rod's going to focus on digital equity and social justice in the context of our privacy conversation. And then we've also got, as I mentioned, John Roberts, the Ontario Government's Chief Privacy Officer, who's here to say a few words about the consultation process, but mostly here to listen to what our sector has to say. And before I give John the opportunity to speak, I just wanted to provide a bit of context from ONN's position and as chair of the Data Policy Coalition. So a lot of you may know, you might have seen it, the Ontario government released a discussion paper that hints at new privacy legislation to come. It's aimed at both for-profit companies and nonprofits, and that includes everyone from service providers, campaigners, volunteer-only groups, labor unions, and also political parties. And the new legislation would essentially create a framework of responsibilities for the private and nonprofit sectors that handle personal data. The legislation is seeking to fill a gap that's left by the fact that federal legislation doesn't generally cover nonprofits. And as Teresa will tell us in a minute, BC, Quebec, and Alberta have similar legislation that national nonprofits, for example, would likely already comply with. And here in Ontario, we're at the pre-legislative consultation stage, so there's still time to get organized, to influence the legislation, but also think about what nonprofits need in the way of an education program and how we can get ready for the new requirements. So just to give you a flavor of what's potentially in scope, some of you may have heard of the GDPR, and that's Europe's General Data Protection Regulation, which has a focus on the consensual use of data and includes the right to be forgotten and the right to request data from a company if it's about you. And the GDPR is kind of considered a bit of a gold standard for privacy protection, and governments around the world are looking at the extent to which they can emulate that. So the stated purpose of the new Ontario legislation is to address the gaps in Ontario's legislative privacy framework and to establish comprehensive, up-to-date rules that will protect privacy rights and increase confidence in digital services. And this is to be balanced with not placing unnecessary burdens on business or hampering innovation. So at ONN, we're working with Powered by Data and the Data Policy Coalition that we convened together we've drafted a response that will go in later this week. And we're emphasizing the importance of centering equity and data ownership in the conversation. We want to make sure that consultation with nonprofits is ongoing as the legislation is developed, so that we can talk about what it means for both the data that nonprofits steward and their advocacy work for equity and privacy, as well as the impact of the for-profit data economy on individuals, especially equity-seeking groups. We've also raised issues around the capacity of nonprofits to adopt new privacy frameworks, and especially here thinking of the 25,000 organizations in Ontario that don't have paid staff, and particularly at a time of great stress as we're in right now. We're hoping the implementation timeline will take into account the pandemic and the economic downturn that we're all dealing with. We also touched base with the fundraising community just to discuss how it could affect them. And if you're interested in seeing our draft submission, let me know by email. I think that's about enough for me just to kind of set the table for the conversation. So I'll hand things over to John Roberts, Ontario's Chief Privacy Officer, to say a few words before our first presenter. So with that, over to you, John.
Thanks, Liz, and huge thank you to the ONN for organising today's webinar, and more broadly for drawing the consultations to the attention of your members, as well as participating directly and providing us with feedback, both already in the process verbally and as you mentioned, the submission that you're preparing. So Just to give a little bit of context around the process, because as you say, I'm really here to listen in today. I'd say we're in that listening phase. So we are at the moment right at the end of our consultation phase, and I know that ONN has brought the discussion paper to the attention of members. It's been out there for a little while. So over the last several weeks, 6 weeks I think it is, we've been having a number of invitational roundtables with various groups. We held in the last fortnight a couple of open town halls and have been receiving the start of a steady flow of written submissions already coming in. So you've already sort of summarised some of the stuff that we're raising in our discussion paper, and I would just say this is an issue that is not new. We've been hearing from Ontarians for some time that privacy is something that really matters to people. That's come through in discussions about consumer protection. It came through very loudly in the consultations last year around digital and data strategy for the province, and has been asserted in a number of surveys and exercises that the province has run. So we know that this is an issue that matters to Ontarians, but we also believe it's an issue that matters to businesses and not-for-profit corporations. We're starting from the position that we do need to be addressing what does privacy mean in 2020 and beyond, and that dated laws are giving increasingly fuzzy advice on what privacy really means. But we also start from the position that organisations, whether commercial or not, do in general respect the interests of Ontarians and want to do the right thing. So this is not about trying to impose overly onerous arrangements or suppress practices. We think there's a win-win where innovation, effective governance and the public interest all come together. So that said, we do not have a draft bill sitting in a bottom drawer ready to be introduced. When I said this is the listening phase, the issues that are surfaced in our discussion paper are very much about the areas that we think are most fertile ground for discussion, and the things that have come up most frequently in previous interactions, previous consultations. So for those of you who are here today hoping that we're going to be giving you a primer on how to prepare, the legislation is not at that stage of detail yet. But we are very much wanting to understand what is the stuff that matters to you as a really important part of Ontario's society. How can we all build a regime that actually creates the kind of respect for Ontarians' privacy that we hear repeatedly as an important feature of the Ontario that we want to live in? And how can we do that in a way that is also realistic and achievable and supportive of the contribution that is made by all sorts of groups, whether they are not-for-profits, whether they are small mom-and-pop stores, whether they are large innovation data businesses. Ontario organisations and entities do not come in just one size or flavour. So part of the complexity is building a regime that works for everyone, that does respect the Ontario as it is now, with all of its diversity and social justice concerns, as well as the opportunities of data to enhance people's lives, and the risks of uncontrolled data practices actually creating a lot of discomfort for people. Mm-hmm. So in summary, I'd say please participate in this exercise. This is a genuine opportunity for your voices to shape the advice that we bring forward to government. We have been delighted to receive a lot of input to date, and looking forward to hearing contributions today. Submissions both from ONN and from anyone who is on the line. While our close date for submissions is Friday, that's just takes us then into the next phase of the process, where I think we will continue to want input and contributions as we proceed along the journey of advising government and ultimately trying to improve privacy protection for Ontarians. So thank you all for your participation today.
Okay, thank you so much, John. That's really helpful. And we will share information about how to submit in our follow-up email from the webinar. Thank you. Okay, and with that, just a reminder to put any questions in the question box for our presenters, and I'll be keeping an eye on those. And with that, I'll turn it over to Professor Teresa Scazza from the University of Ottawa to give us a big picture context piece. So over to you, Teresa.
Thank you so much, Liz. And I have slides for my presentation, so I don't, there we go, there's the title slide. So I'll start on the next slide, please. Right, so I thought it's just begin by setting the context for this proposed legislative change. Right now, we have a federal private sector data protection legislation called the Personal Information Protection and Electronic Documents Act, affectionately known as PIPEDA or PIPEDA, depending on how you pronounce it. And it is a product of our constitutional framework in Canada. And so the application of PIPEDA is part of what I think is driving, or is certainly a factor in driving Ontario's interest in a private sector, in its own private sector data protection laws. So PIPEDA applies to interprovincial and cross-border activities. So where data is flowing across provincial or national boundaries, PIPEDA will apply. It also applies to federally regulated sectors, interprovincial transportation, train, trucking, the air travel, the aeronautic sector, and so on. So anything that's federally regulated in Canada. And it also applies to activities within the province, so intra-provincial activities in those provinces that do not have substantially similar legislation. And currently Ontario is one of those provinces. To date, only BC, Alberta, and Quebec have enacted substantially similar private sector data protection legislation. So in those provinces, activities of businesses or organizations that take place entirely within the boundaries of those provinces are governed by their private sector data protection laws. But in a province such as in Ontario, PIPEDA is the governing statute. PIPEDA applies to organizations broadly defined to include an association, a partnership, a person, and a trade union. So it sounds quite broad at the outset. But I'll talk a little bit more about that in a second. It also applies to employment relationships, but because of this division of powers situation, it only applies to employment relationships in connection with the operation of a federal work, undertaking, or business. So it doesn't apply to employment relationships in elsewhere in Ontario, for example. So this is one of the gaps in coverage of PIPEDA. So we have a private sector data protection law. It does apply in Ontario, but there are gaps. And one of them is with respect to employees. And if we can move to the next slide, I'll show you what the other gap is, because organization sounded pretty broad, but PIPEDA only applies to personal information that's collected, used, or disclosed in the course of commercial activity. And that's because the legislation is justified as being within federal jurisdiction because of the federal trade and commerce powers, so there needs to be commercial activity for the legislation to apply. Now, that makes things a little bit complicated because some activities of nonprofits may be commercial. And commercial is not defined in terms of handling money. So if, for example, you have members and you collect membership dues, that's not a commercial activity. If you're fundraising, that's not a commercial activity. But if you're selling or bartering donor lists, that is a commercial activity, and that's specifically mentioned in PIPEDA. So PIPEDA has this kind of spotty application when it comes to things that are otherwise within provincial jurisdictions, such as employment in the province, or nonprofits when it comes to their non-commercial activities. it also doesn't apply to volunteers, and that leaves a big gap in terms of personal information coverage and data protection in the province. Now, Liz already mentioned the EU's general data protection regulation, and this regulation has been pushing Canada towards more stringent data protection. And the reason for that is because the Europeans are powerful enough as a bloc to say that the data of European citizens cannot be processed in countries that don't have legislation that offers an equivalent protection to what is available in Europe. And the way data flows across borders, it would be a real hit to any country's economy, including Canada's economy, if the data of European residents could not flow to Canada, to Canadian businesses, and so on. And so Canada's been under a lot of pressure to upgrade its laws in order to offer an adequate level of protection under the standards set by the GDPR. And this is across the board and across all sectors. So it's not just a question of whether PIPEDA meets the standards set in the GDPR, which it currently doesn't, and the federal government's trying to do something about that. How hard they're trying remains to be seen, but anyway. So it's not just about PIPEDA, but it's about public sector data protection legislation as well, and it's about what's happening within provinces. And so this may be another incentive for Ontario to up its game with respect to some of those sectors that I mentioned that where there are gaps in coverage because PIPEDA doesn't apply. Quebec has responded to the GDPR pressure and has a Bill 64, which is before its National Assembly, to reform public and private sector data protection laws in that province. BC has been consulting on reforming its legislation, and a PIPEDA reform bill is expected maybe this month, maybe next month. You know, these are the rumors I've heard, but then I've been hearing very similar rumors for years now. But anyway, but something is expected from the federal level. But that doesn't mean that Ontario doesn't have to act or can't act if it decides to do that. There's certainly lots of room for Ontario to act in this space. Part of what GDPR requires will lead to most of these legislative reforms, including key obligations that are oriented towards providing individuals with greater control over their personal information, including the right to move their information from one organization to another, including possibly the right to erasure, the right to basically go to an organization and say, not only do I want you to stop collecting information about me, but I want you to erase what you have or get rid of what you have. Some provisions will address the impacts of artificial intelligence, and stiffer enforcement and oversight provisions are also expected. And so these are going to be changes. These are going to be aspects that you see in all new legislation. And if Ontario acts in this area, it's probably going to have to address these issues as well. Next slide, please. Right. So some of the gaps that could be filled by provincial legislation in this space, I've already mentioned employee personal information for organizations other than federal works undertakings or businesses. Now, the scope or extent of protection for employee personal information is not enormous. It's not that any province, particularly you know, Alberta, Quebec, or BC, or even the federal level, offer enormous protections for employee privacy, but they at least address employee privacy. And so there's certainly scope to legislate with respect to the provincially regulated sector. The non-commercial activities of nonprofits is another area, because commercial activities are already covered by PIPEDA, but non-commercial activities are not, and that can include their relationships with volunteers, their fundraising activities, you know, basically any other activity in which personal information is involved. And so that's another area where the government could choose to act. Now, it can also choose to pass private sector data protection legislation and not address these areas, but these are certainly gaps in terms of what the current legislation doesn't fill. Non-commercial activities of unions. So trade unions are not, could be captured by this legislation in terms of their non-commercial activities. The federal legislation only applies to unions with respect to their commercial activities. And so there's a lot of non-commercial activities, and it could have an impact on trade unions. And of course, political parties, but these would be provincial political parties, but that's still a very significant gap currently in the legislation. So these are some of the areas where I think where Ontario legislation could step in and fill these gaps, and where PIPEDA never will be able to. So if it doesn't come from Ontario, it's not coming at all. It's not coming in the federal reforms. There's no other place for it. This is stuff that has to come from Ontario. Next slide, please. Yeah, tried to do a chart indicating some of the pros and cons of these changes. The first one was better and more comprehensive protection for personal data. And I thought for 2 seconds about the con, and then I thought, well, there isn't a con. That's actually a good thing. So that would be one advantage, is just to have better and more comprehensive data protection. Another advantage from an Ontario perspective is to have a single regulator, the Ontario Information and Privacy Commissioner's Office, for public, most private sector, and health sector data protection issues. So you've got a go-to person, a go-to organization or entity. It's simpler for the public to know who to go to. It allows for development of consistent policies across all 3 statutes. A disadvantage of not acting is what we currently have, which is a multiplication of data protection laws that create confusion, especially for a disadvantage of acting is to have yet another statute that people have to figure out and manage. And so we already have a lot of different statutes, and this would be another one. And so some might see this as just being even more confusing, because now you have to think, is it federal private sector, or is it provincial private sector, or is it intra or interprovincial? An advantage is more comprehensive protection of the personal data of Ontarians and their dealings with all organizations. So rather than just have some that are covered and some that are not, you would have all organizations covered, commercial or non-commercial. The disadvantage Liz has already touched on, which is increased regulatory burden for those organizations that are newly included and haven't been complying with the legislation up until this point. It's a particularly challenging time, as Liz has mentioned, and there's also a burden on small and medium-sized businesses that have already been complying with PIPEDA, but that are now going to have to figure out whether they are also compliant with the provincial law, which will now be applying to them, and whether they have to do anything differently. So that's a disadvantage. Another advantage is more autonomy over the development and enforcement of data protection norms in a rapidly expanding information economy. In other words, Ontario gets to decide what it's going to do and when it's going to do it. And I've made several references so far to us all waiting for the federal government to act on modernizing their legislation. We wouldn't have to wait as long, certainly for things within Ontario's jurisdiction. If Ontario were free to act, of course, there's no guarantee that a future Ontario government would act quickly either. A disadvantage there is additional cost to the public purse. Right now, we're getting free data protection services from the Office of the Privacy Commissioner of Canada for the private sector data protection. We would have to pick that up and pay for it, right, in Ontario. So that is a disadvantage. And I would note also that if we don't do it at an appropriate funding level, then we get de facto lower protection, because the regulator will not be able to cope with the burden. So these are important things to think about in terms of the pros and cons. And I think I have one more slide, but I'm not sure. Yes, sorry. So very briefly, because I don't want to take up too much time, there are certain issues to consider, because, as John mentioned, this is not all set in stone yet. This is just a consultation period. And there are different things that can be done. So in BC, for example, they cover all activities of nonprofit organizations. Whereas in Alberta, they've chosen to cover only the commercial activities of nonprofit associations. So that division could be replicated. I'm not sure there's a justification for that. Certainly the Commissioner in Alberta thinks it's a mistake, and that their laws should be amended to cover all activities. But there are different approaches that are taken. Grandfathering provisions are really important. What happens to the data that nonprofits have already collected and already have in their possession if there's a new law? And so the statute can provide that all information that's been collected prior to the coming into effect date can be assumed to have been collected with consent. And so then going forward, you need to get consent, but you don't need to start figuring out how you're going to get consent for the information you already have. So grandfathering is an important consideration. An important balancing of competing rights or interests, and I'm sure Brenda and Rodney may speak to this as well. If you extend the law to the non-commercial activities of unions, you're going to have to address freedom of expression issues, which Alberta was required to do in its legislation. And there may be other adjustments that need to be made. And because to be GDPR compliant, it's necessary to address appropriate levels of enforcement, sanction, oversight, monitoring, and so on. Then thought has to be given to what is appropriate for nonprofit organizations and small to medium enterprises, that you can't just have a big stick that you club everyone with. The stick that you take to Facebook is not necessarily the stick that you take to a local volunteer organization. So these are going to be things that will have to be addressed in the legislation. And I'll just stop there. Thank you very much.
Okay, thank you so much, Teresa. That's got us off to a wonderful start. So without further ado, I'll hand things over to Brenda Mcphail from the Canadian Civil Liberties Association. Over to you, Brenda. I think you may still be muted.
Sorry about that.
Oh, there we go.
The inevitable webinar gaffe. The talk with the mic still muted. On that excellent start, we'll move. I'll head forward. So CCLA is an organization that has been protecting rights and freedoms in Canada since 1964. I approached the topic of new privacy laws for Ontario in two ways. As a privacy advocate in an organization that advocates for civil liberties and rights, and as an organization that has been calling for modernized, updated privacy legislation for Ontarians and Canadians for many years now. And also as a member myself of a nonprofit organization who may well be newly covered by this particular piece of legislation that we're talking about today. And so, with all of the same concerns that many nonprofits have when they run on shoestring budgets with tiny staffs, largely supplemented by volunteer engagement. So those are sort of the two different prongs that I'll approach in the next 9.5 minutes. I'm going to start with a wish list of the things that CCLA hopes a modern privacy law would include. It's not comprehensive. It doesn't cover the sort of basics that are already present in privacy law. It's some of those gaps that Teresa was mentioning and a few more in terms of what we think we need to have a rights-respecting privacy landscape in Ontario. And I'm doing this very much from a perspective of understanding that data has a huge value, not just for businesses and commercial interactions, but for public good. And we need to have laws that do facilitate the ethical uses of data for applications, both for profit and for that public good. It's also from the perspective that we are very much in a time, I think, of where there's a crisis of trust from members of the public with the ways that their information is currently protected by privacy regimes in Ontario and in Canada more broadly. So it's really important in creating sort of a contemporary privacy regime that we take that crisis into account, and that we come up with something that's strong and flexible and principled and enforceable, that can provide that sort of foundational level of trust that's going to be necessary for any sort of data-based information economy. So wish list item number one, we need a human rights-based approach to privacy law. Teresa has literally written the paper advising the Federal Privacy Commissioner of Canada that this is a doable approach for privacy law in Canada. The first step to reimagining our private sector privacy regime needs to be a commitment to privacy as a human right. That's fundamental, both because it will bring us closer in lines with international standards, so looking towards that GDPR equivalency that Teresa was talking about, but also because it provides the sort of principled protection in a framework upfront that allows us then to look at privacy not as something that individual Ontarians or consumers, residents, citizens can be asked to trade away if somebody thinks it's a good idea for their business, or for a government program, but as something that people deserve because they're human, because it's fundamental to exercising, to being who we are as individuals with autonomy and dignity in society. And the law needs to reflect that, emerging and fundamentally international understanding of privacy as a human right. The new privacy law needs to address changes in technology and changes in the way that data has consequential impacts on our lives. So a common example is biometric technologies like facial recognition, which present growing challenges to democratic societies that can be difficult to escape if they're employed in public settings, that carry with them severe privacy implications and also very profound equality implications, because of course privacy is a gateway right for many of our other charter protected rights, including freedom of expression, freedom of assembly, and equality. So we need a privacy that's going to be complicated and it's going to be hard, and technologically neutral laws have served us very well. But at the same time, we need to think about how we can include principled protections for things like biometrics and specifically facial recognition. The other emerging technology that's really important, of course, is artificial intelligence. So we need provisions that ensure that automated processing, particularly when it's used for decisions about people, are explainable, they're transparent, they are capable of being interrogated, and they're implemented in ways that are both privacy protective and equality protective. Some of that a privacy law can probably do, and some of it can't. But as part of this wonderful opportunity to have these open conversations about what privacy law needs to do, which can include what kind of protections we need in a data-driven world that aren't well addressed by privacy, but that are sort of side effects of a surveillance society that go beyond a technical definition of privacy. I mean, that's part of the conversation that I think it's really valuable and exciting to be able to have as part of these Ontario consultations. And some of the issues around algorithms probably fall into that camp. De-identified information is another huge item on the wish list. There's a lot of public debate at the moment about whether or not de-identified information is or is not within the scope of existing privacy legislation. Some commissioners are very clear on the idea that it probably is. Many corporations are very clear on the idea that it's not and are operating their businesses as though it isn't. Made in Ontario contemporary privacy law would need to address the issue of de-identified information, which is, personal information that's been altered or changed. So there's a strong principled argument that individuals whose information it is still care about what happens to it. It still matters to them if it's used for purposes that they didn't expect or weren't or would never have consented to if they were asked, even if that information doesn't say their name, because it includes other consequential information about them and is being used for purposes that are consequential to them and others like them in society. We need enhanced privacy protections for specific vulnerable groups. So employee privacy and youth privacy is another area where we need to be thinking about whether or not young people are particularly vulnerable and whether we need some sort of specific provisions which are not currently present in privacy laws in Canada for vulnerable youth. Specific to nonprofits, I think that there are really strong principled reasons to include nonprofits in a piece of privacy legislation, because many of us do collect information about people, and many nonprofits use that information in ways that corporations also do, to understand who our constituents are, to reach out to them, to provide information, sometimes even to attempt to influence them, particularly those of us who rely on donations, right? So there are principled reasons why we do this. There are also huge hurdles because there's big variety across the nonprofit sector. We don't all do the same things. We don't all have the same resources. Some people collect frontline service organizations and collect client information. Others, it's all about donor information. And then you've got very small nonprofit volunteer-run organizations like the soccer club that organizes your kids' local soccer league, where they are collecting personal information, and it is information about vulnerable youth. It's names and information about children. So there's reasons why you'd want to make sure that those organizations understand their obligations to protect privacy, but also huge resource implications and capacity issues when it comes to those kinds of organizations, including in their capacity to understand the legislation, to hire someone to help them to understand, and ultimately to comply. So there are a lot of reasons why we need to think positively about the idea of bringing nonprofits into this regime, but there are also really big barriers that I think today's conversation is an important part of starting to tease out and bring out with members of the nonprofit community. And you probably all heard my beep, so I'm going to stop.
I love speakers who set their own time. Thank you so much, Brenda. That's really helpful. And as you say, this is just the beginning of the conversation, so just starting to open it up. Yes, thank you. And with that, I'll turn things over to Rodney Burns from the Alliance for Healthier Communities. Over to you, Rod.
Thanks, Liz. And I'll preface, I also have a timer here to try to keep me on track because I can talk about this stuff forever. Thank you for inviting me to have a few comments about our work at the Alliance. For those of you who don't know, we are an association representing over 110 comprehensive primary healthcare organizations. They're all not-for-profit, interprofessional, team-based, salaried clinicians. There's no fee for service. These are folks that work for a salary, whether they're a doctor, a nurse, a social worker, a dietitian, peer outreach worker, street-informed, harm reduction programs. Most of the consumption treatment services are provided through community health centers in the province of Ontario. We're bounded by a provincial perspective. So I also serve as a privacy officer and have done so for about 20 years in other parts of the healthcare sector. The Alliance has members who are not only in healthcare, but also community support. So we've got a foot in each camp, making life real interesting. And I would add to the incredible comments from Teresa and Brenda about how to think about privacy when you also layer on complexities associated with governance and data sovereignty for our Indigenous communities and First Nations in trying to support that. So, these folks are giants amongst me here. I'm in their shadow, and I'm just trying to help our members sort out how do we move forward? How do we do what we are trying to do? And our members have made a board level commitment to serving those that face barriers to health and well-being in the province. We don't necessarily call them citizens because not everybody here is a landed immigrant, right? They show up. So I think, our first advice to the government of Ontario when they did their data strategy was to say, look, you need to be thinking about consistent biometric-based identity for everybody so that we can actually know who we're talking about across all government services and not just a sector at a time. So how do we actually create insight of an individual living in Ontario's journey through any services that the government funds? The next is actually thinking about a digital world, and as it's growing, how do we really prevent the inclusion of barriers to digital participation? It's one thing for organizations to mine your personal health information in a digital format. It's a lot easier to do it that way. So what we're seeing is many of our members saying, I live in Moose Jaw, I live in Kenora, I live in Cornwall, where rural internet or remote internet services are not adequate for me to participate digitally. So thinking about getting good, reliable broadband internet services border to border to border is a really important element. From there, most folks may not know that one of the key drivers of poor health is poverty. And certainly, I don't have the dollars to fund a device or a data plan. How do we help people remove financial limitations as a barrier? And certainly some of the work we've been doing around digital inclusion, I took a lesson from the city of Seattle. and the City of Vancouver. And in fact, one of the trusts in the NHS, as we're building our own digital equity call for action, is don't forget that for individuals, even if you remove the financial barriers of device and internet, free Wi-Fi, which certainly members of the private sector can participate in supporting, and we certainly saw a huge impact when COVID hit and people shut their shops up, including their internet access. So those folks who are homeless no longer had access to connect. And so they also were impacted from a social perspective, not necessarily being able to connect with friends or family. So we consider digital inclusion or the right for digital equity to be a social determinant of health. And it's a part of the mandate of our members. They sign at the board level to support health equity and capturing race-based data to be able to demonstrate that you're actually serving the most vulnerable in your particular catchment population. So from my perspective, this is about trust. An organization, an individual provider, you will only interact with if you trust them, right? So whether it's government, your doctor, the used car salesman, if you don't trust them, you're not likely to engage and to participate. So thinking about privacy and turning the power to the individual to say, yes, I want to be forgotten. I don't want my information being used. There's a massive case being made for the cost of collecting all this information and how can we get the most value out of it. That I get, but it has to be grounded in the individual being aware of where their information is going, whether it's identified or de-identified. And we've certainly heard in the work we've been doing with big data sets that even de-identified data with the power of AI and some of the computing capabilities out there is re-identifiable. Not good. That does nothing to promote trust, right? So to reach that state of trust implies people not only have the ability to access and participate, but they have the skills and the knowledge. If they're not English speaking, if they have a disability that prevent them from participating, how do we enable them to actually participate in a digital world that's only going to grow? So for us, I think there's a policy framework. Privacy is core to building that trust. Government must have a sense of transparency and how they're using data and making sure there's no surprises. I have 3 20-somethings as children, they're young 20s, and they'll trade their PHI for convenience, right? If I want to get access to a new app or whatever, and I keep telling them, remember, if you don't pay for it, you're the product at the end of the day. And there's big business. I don't believe the general public truly appreciates the market for population data and the data sets that are traded, right? So it can inform policy for government. It can certainly be used by researchers. It can, provide insights. But for me, it's how do we help engage at the individual and the community level to be aware of where your data is going, and how do we help our provider organizations understand that they are serving the most vulnerable in our province. So for me, I think at the end of the day, we had the Privacy Commissioner of Ontario speak to our privacy officers a couple of weeks ago, and they were messaging similar to what Teresa was saying, contemplated changes to the Personal Health Information Protection Act in Ontario, referencing GDPR and making statements like Ontario's next generation provincial privacy is going to exceed GDPR. This is where all the gray comes from. Trying to figure out the implications. When you think about dropping a small pebble into a pond, it ripples and it grows. So, a lot of our work is about trying to work with experts out there to say, what are the implications when we're trying to bridge a digital divide that is only growing and still preserving that trust relationship with people that face vulnerabilities to participating in a digital society at the end of the day. We believe that it's really not only the Alliance that needs to come to the table, it's organizations like Brenda's, it's government, it's municipalities, it's private sector, it's other providers out there using a collective impact approach to say, we can make a difference going forward. We can be part of digital literacy, capacity building, helping people understand how to use devices safely in a world where the internet is the Wild West in many ways. And the last thing we want is Dr. Google telling people what to do, right? So there are a lot of elements to this that really need to be figured out. I think the benefit outweighs the risk, but we have to be very diligent that we aren't creating more gaps, more risk, or undermining, the trust of some of the folks that come from countries where government is not to be trusted, right? Or, institutions. So these are folks that are already, in many ways, feeling like they are isolated and alone. And a digital strategy with proper privacy protections, I don't have the answer, but I think we can figure it out as a society, and certainly figure out how to help inform people that don't necessarily have the capacity to understand the implications and boil it down. This is about empowering you, your family, and making sure you know where your information is being used, and is it being used in your best interests at the end of the day, right? So I think having evidence is easier said than done, but it can be done, and there's examples around the world where organizations and governments are doing it. I think the EU with GDPR is a step forward. California's Consumer Act is a step forward. Provinces in Ontario are moving this forward for sure, but I think we have to take it right down to the individual and help them understand, because none of us have law degrees except these folks here that's play in the law space every day. But how do we move about our daily business understanding what our rights are and what is in our best interest at the end of the day? So certainly easier said than done, but this is something we are kicking up and creating a partnership of the willing to help support the vulnerable populations out there, and helping those folks understand, why are we asking how much money does your household make when you're talking about a healthcare visit, right? Income and poverty is a big impact on health. Why are you asking me about race-based data? Well, if we are serving those populations that face barriers, and our organizations prioritized Indigenous communities, Francophone, anti-Black racism, as well as LGBTQ, we need to know. If you don't measure, you can't manage, but it has to be in their interest. If it's getting used for secondary purposes without their awareness, that's a problem. So we feel it's really important to be able to confidently communicate and educate our clients as to why we're asking for that information, how it's going to be used in the delivery of services that best meet their needs. So with that, I'm going to wrap up my comments as well.
Thank you so much, Rod. That's really helpful. I'm just astonished at the wonderful insights we've had, and we've got a great foundation for moving this conversation forward. I actually have a few questions for folks that have come in through the question function. I'm going to make sure that any that don't get answered here, we're going to have a follow-up blog post or something so that they all get answered one way or another. Teresa has to leave in a couple of minutes, so I'm going to start with a question for her. I think there was a fairly quick one when you were talking about the application of PIPEDA, and there was a question about whether it applies to arts organizations' ticket sales, which is, I think, a quick yes or no. But there was also a question about PIPEDA application regarding client data collected to improve services at nonprofits. So if you took postal codes, for example, could you share those postal codes between nonprofits? So I'll give that one to you, Teresa, and then I know you have to go.
Okay, thanks so much. I like to avoid giving legal advice, partly because it would be irresponsible, and partly because I have non-practicing status with the bar. But stopping short of that, for the art sales, I mean, usually most lawyers also start with in answering questions with "it depends," and then they have to collect a whole lot more information. For the art sales question and the art sales tickets, I mean, if it's a question of PIPEDA, PIPEDA applies to commercial activities, and some activities, and so it really depends on whether something is considered a commercial activity or not. If it's a cost recovery activity, it may or may not be a commercial activity. So the context does matter to some extent. So that doesn't really answer your question. It just indicates that there may be a gray zone depending on the particular context in which this is taking place. Perhaps that goes to underline Rodney's concerns that these are things that then get complicated for nonprofits and other groups, because it's it's not clear where the line is drawn, and then you have to figure out where the line is drawn to know, you know, whether you're compliant with the legislation or not. So, so that's one of those situations. The postal code example is an interesting one. Postal codes aren't generally considered personal information, except that the definition of personal information is quite broad. And so the issue is whether whether that information, if linked with other available information, could lead to the re-identification of an individual. And so a list of postal codes on its own might look like it contains no personal information, but that list of postal codes combined with other information where there's sort of connecting the dots and cross-matching and associating information with postal codes could very quickly lead to the identification of specific individuals at those addresses. And once that happens, then it's personal information. And again, that's another instance where something that may not seem evident on its face to ordinary individuals would actually, under the legislation, fall within the definition of personal information in a particular context. And so those are questions that I can't give 100% answers to, but I maybe can underline, you know, what some of the uncertainties are in interpreting and applying privacy legislation.
Okay. Thank you, Teresa. No, that's very helpful. And with that, I'll give you a big thank you for joining us and let you go.
Thank you so much.
The conversation will be continued. Thank you.
Thank you.
Brenda, I have a question for you. It's around recording staff meetings. And at one organization, a staff member expressed concern. They're not comfortable being recorded. You know, what are the privacy implications of recording staff meetings? So would you like to comment on that?
Muting, yay.
There we go, there we go.
So the devil is always in the details when it comes to thinking through what privacy implications are going to be. So some of the questions are, why do you need to record? What is the purpose of the recording? Who's going to access the recording? How's the recording going to be stored? Is there a retention schedule? Are you going to keep the recordings so that, you know, the secretary can make the minutes and make sure that they're accurate and representative of the actual conversation that you had in your room, and then destroy them when they're no longer needed? Or are you going to pop them in a file folder somewhere and keep them? If you're going to keep them, how are you keeping them safe? And how are you making sure that they're not accessed or used in the future for purposes that that were not intended at the time of the recording? And then, of course, again, it comes back to those purposes as well. What do you intend to do with the recording? What's the reason for doing it? So principles of data minimization suggest that you collect as little as possible and keep it for as short a time as possible.
Okay.
And, you know, you do that within the framework of what your need for the information is.
Okay, thank you. No, that makes sense. Okay. Rod, I've got one for you. Because I know we don't have a lot of time left. I wondered if you have advice for the nonprofit sector in engaging with government on the proposed legislation. Are there lessons from previous advocacy initiatives that we should know about, or what advice might you have?
So I think the work of the ONN is a good way of getting a collective voice. At the end of the day, individual organizations can have their opinions, but government, I think, listens to volume and mass, right? If you're representing all not-for-profit organizations, it's going to weigh a little heavier in the minds of government than a mom and pop shop, right? That's only one vote, right? Remember what motivates government at the end of the day. So we have to create what's in their best interests as far as advice and guidance as well as we go forward. So, you know, for me, I think it's looking at other jurisdictions, the concept of collective impact, coming together to say this is in our best interest collectively, whether that's across sectors or representative of an area, a region, you know, a market, what have you, has the most bearing on how government is going to take that advice and think of it in terms of where they're going with their legislative frameworks.
Okay, thank you. And over to Brenda for a question about, I don't know, I'm not sure if this is within your bailiwick, but there's a question around organizations using American programs for fundraising and membership management and so on. So which means that personal information is being shared internationally. Do you see a way for the legislation forthcoming to allow organizations to continue using American software, or is everyone going to have to start using Canadian software? Is that something you would like to respond to?
Yeah, the answer to that is it's super complicated. So that we do have BC as a jurisdiction in Canada where they had legislation requiring information to be retained within provincial boundaries. Okay. There's a question whether or not we can do that under the new NAFTA, the USDMCA agreement. Some of that is still, floating around in the area of vague legal opinion.
Okay.
And some of it is just, we haven't gone there yet. We haven't thought that through yet. But the reality is there is a risk when information is shared across international boundaries. We do know in the US under provisions instituted by President Donald Trump very early on in his term in office, that privacy protections for individuals who are neither American citizens or green card holders are essentially non-existent. So these are all things that any organization would have to take into account when they're doing a privacy impact assessment of the tools that they're using, taking into account their responsibility to be respectful of the privacy of their client base or their participant base.
Okay, yeah, that's a sobering thought for a lot of us. Okay, thank you very much. I know we're running a little over time, so I'm going to suggest that any other questions that came in, and there were a couple that didn't get answered, I'm going to make sure to follow up in a blog post or other public communication vehicle, because I know that the conversation on this topic will have to continue. So with that, I am going to say a big thank you to our speakers, Brenda, Rodney, and Teresa, who had to go, for volunteering their time today. And thank you to John Roberts and his colleagues from Government and Consumer Services for taking the time to listen to our sector's perspectives. Thanks to everyone who joined us. I hope the presentation helped your team better understand what's coming down the pike and how we can help to shape the agenda and prepare for new privacy requirements. So let's stay connected. Please join us for future webinars or become a member, and we hope that you'll keep in touch. And as I say, we'll send out the recording in about a week's time. So to be continued. Thanks everyone for joining. Take care. Bye-bye.
Thank you.